I spent a lot of the last 25 years on both sides of the unemployment side, whether I was between positions because the company I had worked for sold, or I was sitting in a position where, as the employer, I was contesting unemployment insurance. I'm going to talk to you today about 8 ways that you can screw yourself out of your unemployment insurance if you're not careful. You can suddenly find yourself out of a job, and you don't need to worry immediately because in general you're going to be eligible to receive unemployment benefits. Unemployment benefits are paid by the state and federal government, and they provide you with a weekly check, up to about $800 at the top side, to try and help you just bridge through from one job to the next. Most people believe that if you quit your job, you're ineligible for the payments, but that's not always true. Keep in mind that there are certain things, like quitting before the end of an employment agreement or a contract, or being fired from your last position and refusing other work offers, that will make it less likely that you're going to be able to get your unemployment insurance approved. We know that losing a job can be financially and emotionally challenging, and unemployment benefits can help you through that hard time, but only if you qualify. And if you can avoid these 8 mistakes I'm going to cover, you're likely to qualify for those unemployment benefits, which could run up to 26 weeks and help you find that next job of your dreams. The 8 mistakes that can cost you your unemployment insurance start with number one, which is turning down a job offer from your current employer or potentially someone else. If your current employer offers you a better alternative position, it may not be possible for you to collect unemployment if you refuse a new offer. They may be closing a store in one location in your town and opening a store in another, and they may say, hey, you're going to have to drive that extra 10 miles. And you go, forget it, I don't want to do that. You may not be eligible for unemployment if that other position was materially equivalent, and the person at the state, the claims person at the state, says, that 10 miles is not an unreasonable amount of commuting distance to drive in order for you to be able to maintain that job. The level of the position and the salary need to be similar, or an increase from that which was offered before your termination. And those rules will vary state to state. The radius that you'll be expected to drive will vary state by state. The change in duties can vary state by state, and sometimes even adjuster by adjuster or claims person by claims person. So be sure to check with your state about the specific guidelines and your specific unemployment claims person. Now, if it's denied, and we'll talk a little bit about this throughout, but if any of these are denied, you have the right to appeal to an administrative law judge, make your case, and they can overrule the claim. So if you're denied unemployment, you always have an appeal opportunity to be able to go make your case to an administrative law judge and potentially get those unemployment benefits paid. So don't just kind of throw up your hands and go, well, I was denied, I can't do anything. Run through the process. But you're in a much better position if you have all your ducks in a row. And one of those things is not turning down a legitimate job offer from your current employer that is reasonable relative to what you've got today. Number two is going to school full time. Now, it might seem like, hey, if I'm going to school, I'm going to improve my skills, and I've lost my job, I need to get new skills, so I should be able to go to school and get those new skills. In order to get that approved, you need to work with your claims person at state unemployment to make sure that they approve that workforce training. If not, you may be denied unemployment. If going to school limits your ability to work or find employment, your benefits may be denied. Attending classes is fine as long as it doesn't interfere with, or you don't indicate it interferes with, you finding a job. If it interferes with you finding a job, they may go, hey, you're going to have to set school on the side because you're collecting unemployment, which means your number one job from the state's perspective is to go get another job. Taking too many credit hours can also put you in a state of denying future assistance based on the assumption. If you feel like you need to get additional training, work with your state adjuster, and they'll potentially put you into workforce retraining or approve unemployment benefits in addition to your schooling so that you could put yourself in better position for that next job. But if you just assume it and you go through the process and then you're denied because you don't go through the interviewing process, or you turn down a job because you have an opportunity to go to school, you may find yourself on the wrong side of unemployment. Number three, you're unable to work. So unemployment is designed for folks who are between jobs, but they are available to work. And normally you have to log in every week. You go, I am available to work. If you're unable to work due to a temporary condition that may be preventing you from working, it's important that you understand what the rules in place are for collecting unemployment during that time. And those vary, again, state to state. Many states do not allow someone who's on unpaid maternity leave, for instance, to collect unemployment, or is on FMLA to collect unemployment during that time because you're not available to work. And as a result, you have to rely on other forms of insurance like short-term disability or the state's Paid Family Leave Act in order to be able to cover that time off. Different rates of pay may be available to you from the state depending on what state you live in and whether you were fired by your employer because of that condition or that temporary condition, or whether you voluntarily left because of that temporary condition and are returning. So again, work with your state claims adjuster to be able to, or claims representative to be able to determine if you're in a position to collect unemployment in the event of a temporary condition like maternity or FMLA or an injury, but recognize that you may be having to rely on a short-term disability policy, workers' compensation, or some other method of payment, and you may not be eligible for unemployment at all. Number four, you have other income. So if you're generating income, you got a big side hustle going, you're making $100K, your employer fires you because you're too tired to work because you've been working all night at your other gig, and you claim unemployment. The state may go, hey, you've got a job, you're making $100K at your side hustle or your second job, you're not unemployed, you're just less employed than you were a little while ago. Your unemployment benefits may be reduced or eliminated, offset by the amount that you're making in that other job. In most cases, the amount of the benefits a person received is based on how much they make and how much you made in your previous job and what you're currently making today. So sometimes you could get another job and continue to collect some unemployment if it's significantly below or part-time. On the other side of the equation, you have too much income or too much other income and it exceeds that unemployment insurance amount, in which case you're going to collect nothing at all. So if you have significant other income from a second job or a side hustle, that may make it so that you can't collect unemployment. Number five, you're not actively job hunting. The purpose of unemployment is to bridge you between jobs. So if you go, hey, I'm going to take this as a 6-month paid vacation, you may have a problem. There's requirements to maintain eligibility in every state, and most of the time that includes not only certifying that you're willing and available to work for job or to take a job, but you're also actively searching for a job, and they may ask for proof of who did you apply to, and they may follow up with some of those folks, particularly if they don't feel like you're actually following the rules. And we've had situations where I've been the employer, we've offered a job to somebody, they turned it down. A week and a half, 2 weeks later, I get a call from unemployment, and they say, did you offer a job to person X? And I said, yes. And they said, okay, what was the job offer amount and the job position? And you let them know, and they go, okay, thank you. And they go off and go on their merry way. That may or may not have cost that person their unemployment benefits because they turned the job down. Now, it may have been that they were a chief financial officer and we offered them a staff accounting position, and the difference in pay was enough that they were able to talk to their claims adjuster and say, hey, I shouldn't, I can't afford to take a $32,000 a year job when I was making $150,000. I didn't know that it was going to pay that much at the time, in which case you're going to be okay. But if you're not actively job hunting at all, or you're applying for positions that you're not qualified for just to kind of hit the state's requirement of I've got to apply for 5 jobs, 1 job a day, five jobs a week, you may get kind of caught in that trap, and you may lose your unemployment benefits because you're not actively searching. So you've got to be actively hunting for that job during the time you're collecting unemployment. Number 6, depending on how your severance is structured, it may cost you unemployment. In most states, you're not going to be able to receive unemployment during the time of your severance pay if the severance is considered salary continuation. So if your employer goes, look, I'm going to pay you through the end of July, and it's right now the middle of May. I'm going to pay you through the end of July as your severance. You may not be able to collect unemployment until August, because the state will determine that to be salary continuation, and you're not really unemployed. You're just not working, but your pay continued. If you get a lump sum severance for the same amount today on May 20th, and you don't receive anything for the next 2.5 months, you may very well end up eligible for unemployment in 3 weeks. So depending on how that severance is structured, may cost you unemployment benefits. So it's generally going to be to your benefit to take a lump sum payment, not just from a time value of money perspective, but also from the way the unemployment rules are written. And each state is going to be a little bit different. And some states are going to treat, that entire, in the example I gave from May to August as unemployment, and you'll be able to collect unemployment on top of it. Most states do not. So you're going to want to know those going into negotiation for your severance, because you may find that it's better to take a little bit less severance and a lump sum up front than salary continuation over a period of time, depending on what the state laws are. So just be aware of what your state's laws are. Talk to your employment attorney if you have one. If you don't, Google has miraculous ways of giving you that type of information. But how you structure your severance can make or break your eligibility for unemployment. Number 7, misconduct. This is the one that tends to be brought up when you're denied benefits because you're fired. You're expected to act reasonably at work. If you steal from the office, if you have chronic absenteeism, if you fail a drug test and the drug testing is legitimately part of the job, or you've got unreasonable behavior, insubordination, that can preclude you from receiving your unemployment benefits, particularly if you've been written up and warned on it a couple times. And the employer will fire you and then let the state know that you were terminated for cause. And while you can appeal that decision, the state will generally deny unemployment benefits based upon the fact that the employer says you were terminated for cause. And then it becomes you can go to the hearing and kind of show why it shouldn't have been for cause, and you can go through that exercise. And then in many cases, administrative law judges are generally sympathetic to the employee and will allow unemployment benefits. Having said that, if it's a fairly clear-cut case, and I've been on both sides of this equation where we've lost and we've won contested unemployment cases, if you've got a well-documented file and the employer fires you, you've probably got an uphill climb to get qualified for unemployment. The other one is it doesn't just have to be at work. So if you have a CDL and you drive for a living and you lose your license because of a felony DUI, you can be terminated and not collect unemployment insurance. If you go to prison, you can end up in a position where you can't collect unemployment insurance. Crimes of moral turpitude, you can be fired, and depending on a state, you may not be eligible for unemployment insurance. Behaviors outside the workplace that are deemed too extreme for most employers, such as a felony conviction, may result in termination without unemployment benefits. So, misconduct on duty or off is something that can cost you a fair bit for unemployment. And number 8, you quit for no good reason. And I use no good reason specifically because you can quit with a good reason and collect unemployment. And that good reason is generally going to be defined in your state statute, but it's really subjective, and it comes down to the claims person at the state and potentially the administrative law judge if you appeal. If you're thinking about quitting your job and you're worried it might leave you without benefits, there's a good chance that some exemptions are going to apply to protect things like pre-existing health of the employee, if you have unsafe working conditions, if you've been subjected to domestic violence or medical issues, you may be able to receive unemployment insurance coverage even though you had to voluntarily leave. So, if you were in a position where your job required you to stand all day because you were a cashier, for instance, and you ended up with a situation where your leg was injured temporarily or permanently, and your employer was unable to provide you with an accommodation of a different position, and you had to leave your job, you are likely, and you had to quit your job because you couldn't continue physically to do the job, you may be able to collect unemployment benefits, but you're going to need to make sure that's well documented. If you're working in a very unsafe environment and your employer is consistently not following OSHA or state regulations for employer safety, and you quit your job and you've documented those violations, you may be able to collect unemployment. If you're in a job that's high stress, high anxiety, and you're diagnosed with an anxiety disorder and you're required to leave your job at the request of your doctor, you may be able to collect unemployment insurance. So there's ways to be able to collect unemployment even if you quit voluntarily, but you've got to do the homework before you do it and make sure that you've got all your ducks in a row and you understand what the rules and regulations are for your state. With unemployment insurance, you can get that temporary support you need if your job is taken away for reasons outside your control. Unfortunately, not everybody is going to be eligible to receive unemployment benefits in every situation, and it's important for you to understand what the laws are where you live, what the conditions are for your employment, and whether you're going to be in a position to kind of move on from the job you're in, and whether you're going to have a problem staying eligible for unemployment benefits. There's a lot of factors that go into how much you're going to get and whether you're eligible, the amount of time you worked at the last job, how much you made, what you were doing, and why you left. You might be eligible for federal assistance on certain other poverty alleviation plans if you're not eligible for unemployment insurance. And like I said, even if you're denied, you've got the opportunity to appeal. You can get counsel sometimes sometimes free from legal aid societies. You can get assistance online with research. You can talk to an attorney if you have the ability or funds to get one, who can walk you through a lot of these issues and put you in best positions if you need to appeal to the ALJ, Administrative Law Judge. But you don't need to just take that initial denial lying down. You can push back and try and get those unemployment benefits. And most of the time, I found employees represent themselves. If they've got their ducks in a row and they're doing a good job, the Administrative Law Judge doesn't hold the fact that they're not an attorney against them. As a matter of fact, it may work to the employee's advantage. And just lay out your case, and you're going to find that in many cases, the Administrative Law Judge tend to lean toward the employee if the employee's made a good case. There's a lot of factors that go into it. Make sure you don't violate these kind of 8 rules, and you're going to be in a much better position as you bridge through your unemployment gap and drive toward FI. Until next time.